Now we're going to move on to the Illinois Freedom of Information Act. Ensuring Illinois residents can obtain information about their government. That's in a nutshell. Here's my disclaimer again. You know how I love them. Here's the topics that we're going to discuss. What is FOIA? Who is subject to FOIA? FOIA is the shortened version of Freedom of Information Act, so you're going to hear me say FOIA a lot. Who is subject to FOIA? What is a public record? Are there exemptions to records that have to be disclosed? How do you make a request? How do you respond? May a fee be charged? As I said with the Open Meetings Act, there's so much in these acts, so much, and if I really wanted to give you a great education about them, it would take me hours. And I'm trying to give the best information I can in a shortened time frame. So I apologize if this is too elementary. I know a lot of you already serve on board, so I apologize. I don't want to waste your time, but I am trying to make it as comprehensive as possible. So what is FOIA? The Freedom of Information Act is a state statute that provides the public the right to access government documents and records. The premise behind FOIA is that the public has a right to know what the government is doing, and the law provides that a person can ask a public body for a copy of its records on a specific subject, and the public body must provide those records unless there's a specific exemption in the statute or other statutes that protects those records from disclosure. In both the Freedom of Information Act and an Open Meetings Act, there's like a page of the purpose to explain the intentions of the legislature in adopting these acts. And for FOIA, it's so that it's declared to be public policy of the state that all persons are entitled to full and complete information regarding the affairs of government. And access to documents is necessary to enable people to fulfill their duties of discussing public issues fully and freely, making informed political judgments, and monitoring government to ensure that it's being conducted in the public interest. What's the primary requirement of FOIA? Each public body shall make available to any person, and when I say any person, it could be anyone. It doesn't matter that they're not a member of your municipality. It doesn't matter. Any person for inspection or copying all public records except as otherwise provided in the Act or other statutes. Now, who is subject to the FOIA? Public bodies. And the definition of public bodies for Freedom of Information Act is slightly different than the Open Meetings Act, and it doesn't exclude the state legislature. Public body definition includes the state, counties, cities, towns, municipal corporations, schools, universities, colleges, advisory bodies, legislative, executive, boards, committees. Everyone, includes the state's attorneys, includes charter schools, and you need not receive or expend tax revenue to be declared a public body. Now, who is not a public body under the Illinois Freedom of Information Act? Federal agencies are not subject to the Illinois Freedom of Information Act. They're only subject to the federal FOIA. And courts, the court system is not necessarily subject to the Freedom of Information Act, but they have their own open records laws. The next determination that we need to decide to look at is what is a public records for purposes of the Freedom of Information Act? Pretty much everything, but it has to relate to the public body. There's 3 elements that you have to look at. It's all records, regardless of physical form or characteristics, pertaining to the transaction of public business. So when you look at pertaining to the transaction of public business, if public business does not include purely private affairs or personal private correspondence. So if a mayor sends an email to their spouse on a city website saying, hey, I thought I'd take you out to dinner, what do you think? that's not subject to FOIA, because that's not pertaining to the transaction of public business. And then the third element, having been prepared by or for, or having been or being used by, received by, in the possession of, or under the control of any public body. This public record means that it's broader than just any record that's in possession of the public body, and can include records in possession of a third party. A public record that is not in possession of a public body, but is in possession of a party with whom the agency or the body has contracted to perform a governmental function on behalf of the body, and that directly relates to the governmental function and is not otherwise exempt by the Act, shall be considered a public record of the public body for purposes of the Act. So example, even if the city doesn't have a copy of it with them, if they've had an engineer prepare public records, final public records, that record is subject to Freedom of Information Act. Now, those requests still need to be made to the public body and not directly to the engineer, because it's the public body's responsibility to reach out to the engineer. You can't submit a Freedom of Information Act request to the engineer to have them respond. You need to submit it to the public body, okay? There are specific statutory examples of public records in addition to the general definition of public records as contained in the Act. The Freedom of Information Act also sets out specific examples of public records, and I'm just going to let you read those, but it includes one of the things that has come up lately in court cases and Freedom of Information Act reviews, non-binding and binding opinions by the PAC, is whether or not you have to disclose settlement and severance agreements. So it specifically sets out that that is a public record. Within the now I'm back to Open Meetings Act. Fast forward. Freedom of Information Act. Within that act, to assist the public in determining what public records a public body has under its control, the Act requires each public body to develop, maintain, and make available upon request a list of all types of categories of record under its control. The list should be reasonably detailed in order to aid persons in obtaining access to public records, and the list must be immediately available for inspection and copying upon request. Each public body shall also furnish, pursuant to the Act, upon request, a description of the manner in which public records which are stored by means of electronic data to be obtained in a form comprehensible, this is what the Act says specifically, comprehensible to persons lacking knowledge of computer language or printout format. Earlier, someone asked me something about JPEG, and I'm like, yeah, I'm one of those persons lacking knowledge of what mumbo jumbo you're saying. So you have to make things reasonably available and assist people as much as possible. As a side note, I want to really briefly get into private email and text, whether or not those constitute public records. Please, please, please take care if you ever use a private email or private phone or text or other mechanism of... Can everyone hear me? Did that go out? Can you hear me? Okay, just making sure. It sounds different back here. You really must take care when using private equipment, private social media accounts, private texting, private email accounts. Emails pertaining to the transaction of public business are public records, even if they're sent from a private email account. Text messages are a public record if they relate to the transaction of public business, even if it's your own phone. Additionally, there's a Champaign County case that suggests that A text sent by an elected official during an open meeting was public record because it took place when the public body was meeting, even though it was not of public business. Now, acting alone, not considering whether it's public business or private, generally, council members and trustees are not public bodies themselves under the Freedom of Information Act. And their private communications that are not related to business on private devices are not subject to FOIA generally. Now, when you're talking about utilizing private devices, this creates a record-keeping nightmare when you utilize private devices and private email accounts in creating documents that could be deemed public records. The public body has an obligation to maintain the public records. So I always recommend municipalities establish a policy prohibiting use of private devices and emails by public officials and employees. And if they do, then because it's unavoidable, require that they immediately provide a copy of that to the keeper of the records, the FOIA officer or the clerk. Because as a municipal body, you are obligated to disclose that record, even if it's from a private account, if it's a public record under FOIA. That is, if an exception doesn't apply, other exemption. So, best course of practice, don't do it, okay? Now, there are some exceptions. There's a lot of exceptions under FOIA for what doesn't have to be disclosed or provided or inspected or copied as requested. But all records in the custody or possession of a public body are presumed to be available to the public unless the public body proves otherwise through an exemption. Any public body that asserts that a record is exempt from disclosure has the burden of proving by clear and convincing evidence that it's exempt. And partially exempt documents, you still have to, if some of it is not exempt, you have to disclose it. The way to handle the exempt portion is through redacting. Just because a part of it is exempt doesn't mean you don't have to disclose it. You do. You just have to redact. Okay? The other thing that I want to say is, although the Act allows the public body to exempt a request for records for specific reasons, it doesn't require under most circumstances. There are some circumstances, like some crime victim circumstances, that you're required to make the exemption, but under most you're not. What do you mean?
Like if you're saying that in order to get that done that way, you have to redact it. At any time, can that be unredacted?
Well, I always make a copy of it, redact it on the copy, and then disclose it. Is that what you're asking?
Yes, but legally, can it at any time become unredacted to the public?
I guess I'm not understanding your question. It's not. Yes. So, yes, there's programs that can unredact documents. So make sure when you're redacting that you really know what you're doing. Because there's programs that you can go in and redact things, like black it out. but there's other programs. Is that what you're asking? Okay, yes, there's other programs. I don't know how I know this as an attorney. There's other programs that you can somehow unredact. I haven't personally done it, but I'm aware of it. So I like to go in there with my whiteout. If you go in there with your whiteout on the copy and redact it. Now, this is for a written document. I already said I wasn't computer literate, so I don't know how to do it with electronic document. But for like written documents, go in there with whiteout and redact it, and then make a copy of it. That doesn't allow it generally. Now, I'm sure there's some computer guru that can figure it out, but that is a better mechanism to really redact exempt information. Go in with a whiteout with a copy, make a copy of the redacted document, and then give them the copy of the copy. Do you understand what I mean? Okay, so programs that do it, that redact, those aren't always the greatest because there's other programs that can unredact. Get your old school whiteout out. Does that help?
Yes.
Okay. No problem. Good question. Only information specifically exempted by statute is exempt. And like I said, exemptions are narrowly construed. As far as it relates to information that is available through a public body's website, if a public body has a website, a public body is not required to copy a public record that is published on its website. And that public body should notify the requester that it's available online and help them access it. However, if a person requesting the record is unable to reasonably access the record online after being directed to it, the requester may resubmit his or her request stating his or her inability to access it online, and the public body must make it available to them for inspection or copying. There's a lot of people that, while they might have internet, they don't have a printer. So in those circumstances, you're still going to have to copy it, so go ahead and help them out. How to make a FOIA request. Who can file a FOIA request? As I told you, anyone, any person, group, association, they have a right to file a FOIA request to any public body. And how do you make a request? You should submit it in writing. In the request, I generally recommend you include your name, address, date, daytime, phone number so that a public body can contact you if they have questions. Provide as much information as possible on the subject matter. This helps expedite the search. Now, the FOIA says you cannot require them to provide their name. It doesn't have to be provided. But it does, providing contact information to help a public body understand your search sometimes, what you're looking for, that helps. At least provide that. Public bodies can require that FOIA requests be submitted in writing, but they must accept requests by mail, personal delivery, fax, email, or other means. And while they may offer a form for a FOIA request, they cannot require it. And they may accept oral requests, but they're not required to accept it. These requests, these FOIA requests, should be submitted to a public body's designated FOIA officer. Every public body must designate one or more FOIA officers. Must be done. And they must prominently display at their office and make available the name of a FOIA officer, information on how to submit a FOIA, and a brief description of the office, including its purpose, budget, and number of employees. A public body that has a website, and it doesn't matter that their website is operated by part-time people or another office. If you have a website under FOIA Act, unlike the Open Meetings Act, if you have a website under FOIA Act, you must post that information on your website. Now, in responding to a FOIA request, A public body must respond to a FOIA request within 5 business days after the request is received, unless it's extended as authorized by the Freedom of Information Act. The day following the day the request is received is considered day 1. As I said, the statute specifically provides circumstances when the time frame can be extended. If additional time is needed, the public body must notify the requester within the 5 business days after the receipt and identify the statutory reasons for the extension and when the requested information will be produced. Under different provisions of the Act are different time frames for the extension. There's generally it's 5 more days, but there's longer extensions for requests made by recurrent requesters, which is specifically defined in the Act, and voluminous, I can't even say that, requests. So those have different time frames. Now, the authority to deny a request. In addition to denying a request in whole or in part based on a specific exemption, as authorized by state statute, a municipality can also deny a request if it's unduly burdensome. But there's a balancing test to determine whether the public interest outweighs the burden of compliance to determine whether something's unduly burdensome. Before denying a request as unduly burdensome, the public body must give the requester an opportunity to reduce the request to manageable proportions. Additionally, repeat requesters are deemed unduly burdensome under FOIA, but a repeat requester is specifically defined. Just because someone sends it once, twice, 3 times, a lot of requests doesn't matter. Requests from the same person for the same records that are unchanged or identical to records previously provided or properly denied under this Act shall be deemed unduly burdensome. The other thing, FOIA, one of the reasons for sort of a denial, public bodies are not required by FOIA. It doesn't require public bodies to create certain documents, nor is it the law that governs retention of documents. There's another law for that. You're not required generally to create a new document. In some circumstances, you're required to compile, which is different, but not just absolutely create a new document. Now, can a public body charge a fee? Except when a fee is otherwise fixed by a different statute, public bodies may charge fees that are reasonably calculated to reimburse its actual costs for reproducing or certifying public records. If the request is for black and white, general standard letters, 50 pages or less, you cannot charge. If it exceeds 50 pages, you can charge a fee up to a rate of 15 cents per black and white or actual cost for color. Fees may be waived or reduced under certain circumstances when it's determined to be in the public interest. Like I said, documents shall be furnished without charge or at a reduced rate as determined by the public body if the person requesting the document states the specific purpose for the request and indicates that a waiver or reduction of the fee is in the public interest. Waiver or reduction of the fee is in the public interest if the principal purpose of the request is to access and disseminate information regarding the health, safety, and welfare or the legal rights of the general public and is not for the principal purpose of personal or commercial benefit. Finally, remedies for FOIA denials. If you deny a Freedom of Information request, a requester has options for remedies through the Attorney General's Public Access Counselor, and they may also file a lawsuit. In your denial letters, you must notify your requester If you deny in whole or in part any request, you must notify their specific language that you must include to advise them of their rights and the remedies available. You must also notify them of who participated in the decision-making process for the denial. That ends my... I think somebody accidentally put some additional slides. Keep going forward, Clayton. Go forward. Go forward. There we go. Okay, so that ends my presentation on Freedom of Information Act. We did have one really great question. Are there any other questions? Hearing none. Going once, going twice. Done. Thank you all for being such an attentive crowd. I did love your questions. So if at any time you have any other questions, just let me know. Thank you.